This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviat. Tonight we're taking your calls and questions all about workers' comp. So workers' compensation, it's a form of insurance that applies to most workers, but not all workers. It applies in many instances where an employee is hurt on the job, but not all. And there are rules about how you have to report your injury to be sure that you get covered. So tonight's your chance to ask a lot of questions, and we're going to cover a lot of things, including sometimes even things like heart attacks could be considered a workers' comp injury, well, under the right circumstances. Call in your questions, the 31 Law Call number, 256-536-0077. You can also email questions. You can email any legal question any day of the week. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull some out. We'll have some of your email questions tonight. William Meservey is with us tonight from Timberlake and Lee. Glad to have you here tonight.
Glad to be here.
Such a pretty weekend. You had fun
Beautiful
with
weekend.
Scouts this weekend.
We did. We took the Cub Scouts up to the Beckel Nature Reserve out in Gurley, up
Little
Cherry Tree
hiking.
Lane, and hiked to the largest waterfall in Madison County.
Didn't even know
Gorgeous
there was
day.
one up there. I need to go
Yeah,
see.
it's beautiful.
Hope everybody had a good weekend. We have got for you tonight, we're going to get to workers' comp questions in just a minute, but we've got some video to show you. We pull something off of YouTube each week. This is, you make the law call. We show you video, and this is an instance off of, so it's not local, this is something off of YouTube. Boom. This guy, you are kidding. It doesn't stop.
It's a lot of merchandise.
That's a
falling.
lot of merchandise, and no telling how heavy that is. We don't have a report of what the injuries are, but there are people all over the Tennessee Valley driving forklifts as part of their job. That seems awfully weak to me. Did it surprise you that you could lose that much merchandise at a warehouse
It's
like
pretty
that?
high. I mean, if you knock a pylon out, I guess there's nowhere for it to go but down.
So is that, okay, maybe he made an error. Does that keep him from getting workers' comp? Or what if something went wrong with his forklift? Because it seemed to kind of go a little fast there at the beginning.
Potentially it could. So generally speaking, in workers' compensation, it's not going to matter if you are at fault for your own injury. It's also not going to matter, generally speaking, that your employer was at fault for your injury. What is going to matter is that you didn't violate a safety rule, that it was not what we call willful injury, or you were horseplaying or something along those lines. You weren't involved in a fight with your co-employee or anything along those lines. So, the most applicable of the exclusions to workers' comp to that video would potentially be violation of a safety rule, right? So
Okay.
if he did something inside the cab and wasn't supposed to be in reverse or whatever it
Okay.
was, then potentially he wouldn't be entitled to workers' comp. If you notice, though, there's another forklift in there.
Yes.
And so even if his friend had violated, or a co-employee had violated a safety rule in backing into the structure that
Yeah.
caused everything to fall, that's not going to apply to the co-employee.
Okay.
He's going to be entitled to workers' compensation
Okay.
under Alabama law.
Okay. So what is workers' compensation insurance intended to do? Why do we even have this out there? It seems like you could always sue your employer if they did something wrong, right? So what is workers' comp supposed to get us around?
So workers' comp is essentially a compromise, and it really goes back to the Industrial Revolution, and when you had all these people coming off farms and factories to work farms to work in factories.
Yeah.
There was no OSHA. There was nobody coming in and making sure that everything was safe for workers. For the most part, there were no unions at that point. So, essentially, if you were injured on the job, the common law theory of negligence, or the common law cause of action, was failure to provide a safe work environment. But the employee would have to prove that the company had, in some form or fashion, been negligent. And most of them couldn't. And, so their families would starve. The ones who could would get these big settlements, for the time at least, and those would include everything you'd generally be entitled to under common law, right? So that would be medical expenses, it would be pain and suffering, mental anguish, the things you typically think about from a car accident or being injured in some other way. And so the compromise of workers' compensation is simply this: you do not have to prove your employer was at fault. And so in exchange for that, there is no pain and suffering or mental anguish in a workers' compensation claim.
Okay. So you're pretty limited in what you're going to recover.
You are. So it doesn't follow common law. It follows a statutory scheme. Ours is based off of Minnesota's, but it's codified law through Montgomery. and it spells out what you're entitled to, what you're not entitled to, what the exclusions are, what they aren't. And by and large, that's the situation we're left with. But because it is, this statutory scheme, there's some problems with it.
Okay.
Right? So the Alabama Supreme Court has held that parts of our workers' compensation system are unconstitutional. Those haven't been fixed. The last time workers' compensation system was updated was in the late 70s, early 80s. And so one of the multipliers we use in determining the value of someone's workers' compensation claim is $220. Well, when that piece of legislation was put into law, $220 was the average household median income for the state of Alabama. And guess what? No one's updated it. And so if you were injured in 1979 or 1980 or whenever it was, then technically your injury is worth the same in 2023.
Wow.
Even though the dollar's not worth the same. There's been no adjustment to it for cost of living or inflation or anything else.
That seems totally wrong. Do you see any change in that anytime soon? No. Okay.
It's just not an issue people vote on.
Call in your questions if you've got a workers' comp question, 256-536-0077. And we got this email question I wanted to share with you. This one was from Mona. Mona wrote in and said, my boyfriend works for a small company that does cleaning and maintenance work for larger companies in town. He was hurt at a site and no one will tell us how to sign up for workers' comp. Okay. What's important about that to you when you're picking that apart and you do these kind of cases, your firm does these kind of cases? What do we need to deal with?
Well, my first question is, how small of a company is it, right?
Okay.
So if an employer has less than 5 employees, they do not have to provide workers' compensation to their fewer than 5 employees.
Okay.
All right, so that's something to be aware of if you're working for a very small company or a startup. And even some companies that appear to be larger than that, sometimes aren't, right? So they're technically, filling their staff with contract employees or independent contractors, they call them sometimes. So you need to be aware of the size of the company, and that's the first question, right? There's also a requirement in workers' compensation. You have 5 days to provide notice to your employer that you were injured, and people sometimes say, well, that would never come up. It would seem if you were injured, someone at work would know.
They'd know.
But you can injure your back and think you're maybe okay until you wake up the next day. So if that happens on a Friday, then Saturday rolls around and Sunday, and maybe you don't go back to work till Tuesday.
Yeah.
So you can push that line sometimes, right?
Okay.
But by and large, you need to remember you've got 5 days to provide notice to your employer. And as long as you meet that statutory requirement, and again, you weren't injured through horseplay or some other willful form of becoming injured, then by and large, your claim's going to be preserved. So you can then go talk to a lawyer and figure out exactly how to report that to the insurance company or what steps need to be taken.
When you're saying report it within 5 days, what do you actually mean report it? What's good enough? Is it go to your boss and tell them, or do you want to put something in writing? What do you recommend?
There can be implied notice, right? So if your employer called an ambulance for you, you're going to have a pretty good argument that they had noticed that you were injured, right? But the law specifically states that it's written notice. But the courts have upheld that oral notice is fine as well.
Okay.
So, as long as you provide it to them in writing or you call and tell your supervisor, you're going to be covered with regards to that. Writing is always a safe choice because, that creates a paper trail. So an email, a fax, hand in a handwritten note and make a copy of it. And you're going to protect yourself with regards to that. Giving verbal notice, although it's fine, it creates sometimes a situation of a he said, she said, if that supervisor then doesn't report it up the line or do what he's supposed to do.
You can't prove it.
Correct.
Okay, let's talk about some typical injuries that you see, some like repetitive motion injuries. Okay, maybe, are you going to know to report that you're getting carpal tunnel, or doesn't that build up over time?
So
aren't you going to have trouble with that?
That's a relatively new addition to workers' compensation. For the longest time, repetitive motion injuries were not included under workers' compensation. And, with the invention of the typewriter and then the computer, along came a lot of people getting carpal tunnel.
Yeah.
And so the courts then recognized a cause of action specifically within workers' compensation that those type of repetitive motion injuries would be compensable for purposes of Alabama workers' comp. Now, it's not just carpal tunnel, though. You get in and you're working in a factory where you're doing, certain specific motions.
Yeah, all day long.
All day long for hours on end. Those type workers can also develop repetitive motion type injuries. By and large, the majority of workers' compensation injuries tend to be lacerations, tend to be sprains, strains, rolled ankles.
Okay.
Generally speaking, just, sort of run-of-the-mill minor injuries. But then, it can be death. It can be everything in between.
Yeah,
so,
construction jobs, I can imagine the number.
Yeah, and so, those things happen as well. And then you have to go in and address those type situations. So it can be literally the entire spectrum. And so other things have also been opened up to be covered by workers' comp. So by and large, what we call idiopathic injuries, meaning that it is a chronic over time or God gave it to you type of injury versus, an acute, something fell on me, something injured me type injury. So that would typically be heart attack, stroke, anything that like that. Just because you have a stroke on the job doesn't mean it's a compensable injury, right?
Okay.
And for many years, it was never compensable. Now they've found certain circumstances, the courts have recognized that, look, if you're working in a factory and there is no AC and it's 110 degrees in there and you're working for hours on the end and suffer a heart attack, well, then there's going to be some evidence there that your work environment contributed to the cause of the heart attack versus, if you sit at a desk in an air-conditioned office and suffer a heart attack, you're going to have a hard time.
A little different. Okay.
Linking that to, some sort of on-the-job injury versus just,
Let's talk about does your own doctor have to testify as to what your injury is and link it to your work, or what doctor do you use to show that?
Well, that's a great question. So one of the benefits provided by workers' compensation is that they owe you medical treatment for life as it relates to your particular on-the-job injury, right? So if you were to break your arm and require surgery with plates and screws and hardware, workers' compensation has to pay for a lifetime of treatment with regards to that arm. So, if you were to develop post-traumatic arthritis, or if years down the road the hardware had to be removed by surgery, that's going to be covered by workers' comp.
Even years later?
Correct.
Okay.
Now the payoff, or the trade-off rather, is that you don't get to choose your doctor. So you have to treat entirely within the workers' comp system. You have to use their doctors. You have to go through these processes called utilization review, which is they'll get a doctor in Michigan or a retired doctor on the Outer Banks of North Carolina, which I had recently, does nothing but sit in his beach house and deny coverage for people in other states.
Oh my goodness.
And so they can review your medical treatment and say, yeah, he doesn't need that surgery.
Having never actually seen you.
Having actually never seen you. Then it becomes up to your authorized treating workers' compensation physician to appeal to workers' comp. To then get that. And then
that doesn't sound
if
fair.
that fails, there's some administrative process and administrative appeals you can go through. So it can be very challenging to treat within the workers' comp system. But that is the remedy that you have in Alabama if you're injured on the job.
Okay, we'll take a break. Be right back answering more of your questions all about workers' comp. Stay with us.
Watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovian. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're answering your calls and questions all about workers' compensation, being hurt on the job and what to do when that happens to you. William Meservey is with us from Timberlake and League answering those questions, and they do those kind of cases all the time. And we've got Gracie on the line with a question from Huntsville. Hi, Gracie. Thanks for calling. What's your question tonight?
Okay, so I was basically terminated because of job performance.
Okay.
And basically, long story short, I ended up having a stroke during my probationary. So when I was discharged from the hospital, basically I went back to work because I was more concerned about keeping my job versus not taking care of myself first. So long story short, when I went back to work and I worked the job, trying to work basically overtime to build myself back up.
Yeah.
And before the end, before it came down to have my reval, they terminated me. Mm-hmm. And now I have not drawn unemployment. Am I entitled to anything from that?
Yeah, so, again, traditionally, a stroke's not going to be covered under workers' compensation. So here, unless you could prove that in some way your environment contributed significantly to the cause of the stroke, then what happens is, you're left kind of in between a rock and a hard place. So, I don't know the circumstances of what your job was or what you were doing, but for the vast majority of people, they're not going to be able to connect a stroke to their employment. And so, if that occurred during your probationary period, and honestly, even if it didn't, Alabama's an at-will employment state. So, you can't be terminated for one of your constitutionally protected reasons, but you can be fired for just about anything else. Your employer can decide, hey, I don't like people who wear red ties, letting you go, and that's a perfectly good reason to fire somebody in the state of Alabama. Okay. However, workers' comp does provide one additional protection, and that, again, is because it's codified law through the legislature in Montgomery, and they had the foresight to know that, look, a lot of people get hurt on the job, and then we're getting terminated. And the employer's just saying, look, you can't do your job, so we'll see you later.
You're out.
You can reapply when you get better.
Okay.
And they realized that, look, there's a lot of injustice in that. And so they did provide an additional code section that says, essentially, if you are terminated for having filed or maintained a workers' compensation claim, then you have an additional cause of action against your employer for retaliatory discharge. Now, the reality of that is that, by and large, an employer is not going to say, hey, you were injured on the job, so I'm letting you go.
Yeah, they won't say it.
They'll say, hey, you were a minute late coming back from lunch today, and that's just, we just can't allow that to continue, and we're going to let you go. We're so sorry.
Let's talk a little bit about evidence and things that you would gather for something like that. If you think that you've been wronged by your employer in a workers' comp situation, what would you be able, let's assume it's a situation, they fired you because you filed for workers' comp. How do you prove?
It's very difficult to prove, and it a lot of times comes down to the need for witness testimony. So, if there was a co-employee that witnessed the supervisor saying, look, we're letting you go. That's the second time you've hurt that arm. I'm sorry. We'll see you. Then, you've got more than just a he said, she said, because by and large, your employer's not going to raise their hand and say, hey, yeah, I'm sorry. We let him go because he filed a workers' compensation claim. So that helps to have witnesses. I've had it happen a few times that an employer was unsavvy enough to do it in writing. And so, those we've been able to recover for. But for a lot of people, the truth, Sharon, is that they can't prove it.
Yeah.
They can't prove it because, again,
it's not documented.
Thinking it, knowing it, proving it. Three different things.
What is court like if you have to go to court for a workers' comp case?
It's very much similar to going to court on any other type of case, with the exception that in workers' compensation, you are not entitled to a jury of your peers. You get a bench trial. So you get a judge who hears the facts. The judge is going to be familiar with the workers' compensation laws, and then he's going to make some rulings from there. By and large, the court doesn't have a lot of flexibility in what they can do in a case, and I'll give you some examples of that, right? So, for example, as I mentioned earlier in the show, you're entitled to medical treatment for life as it relates to your particular on-the-job injury. By and large, insurance companies do not like that because you are a question mark on their ledger every year as to what your future medical treatment is going to cost them. And so many times they will offer additional funds at the time of settlement to an injured worker in order to close out their future medical benefits. For some people, that's a good idea. For other people, it's not a good idea. So it's very circumstantial and depends on the specific circumstances of your individual case. But for those that do it, they're able to get some additional funds by virtue of closing out those benefits. So that's an option that you can do if you settle with an insurance company, but not something a judge could ever order.
Gotcha. Talk with your lawyer before you take a deal like that. We've got Jeffrey on the line with a question from Tony. Hi, Jeffrey. Thanks for calling. What's your question tonight?
Yeah, I had done some work for a family member that I ended up getting shafted on getting paid.
Okay.
And the turnaround put a lien on the property. And how long does it take for the lien to exceed?
How long would a lien last? Yeah, is that the gist of it?
So I believe that's a mechanic's lien he's referring to. But there are different types of liens that can be placed on a person's property. In injury cases, we see liens placed regularly. The hospital places a lien, but it's not on your house or your car. It's on your case.
Oh,
because they want to go dollar for dollar after the auto insurance money instead of the 20 cents on the dollar that Blue Cross would pay them or the 15 cents on the dollar Medicare would. But in this particular instance, there's a specific time period, and you can call the course to find out exactly what that is, but I believe it's 7 years that has to be renewed. The lien has to be renewed every 7 years. So to the extent it's not, it would presumably roll off. But
Good luck with it, Jeffrey. They're telling us to take a break. We will be right back answering more of your questions all about workers' comp. Stay with us.
Connecting North Alabama is proud.
If you didn't get your questions answered tonight, here's how to get in touch with William Meservey. He is with Timberlake & League, and they are personal injury attorneys, so that's everything from car accidents to medical malpractice, nursing home negligence, workers' comp. The number 256-536-0770 or 800-804-2502. And the website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon Doviat practices family law. She's here in Huntsville locally as well, 256-539-7337, SharonFamilyLaw.com.
Thank you, sir. Last thoughts on workers' comp?
Try not to get injured.
Yeah.
And if you do, the main benefits, workers' compensation, are going to be medical treatment for life, like we discussed, temporary total disability, or 2/3 your average weekly wage, and some sum of money for permanent partial impairment or permanent total disability.
Go talk it over with a lawyer. Thanks for all your questions tonight, and everybody have a safe week.